This conference will now be recorded.
Good evening, folks. I am Tom Doncaster. I'll be your host for this evening's final segment here concerning legacy planning. And so hopefully you'll have some pen and paper handy because we're going to go through quite a bit of information that I believe you'll find very helpful, informative, and educational as well. So just to give you an idea, I am not an attorney. I am not a CPA. I am an accredited investment fiduciary that's been in business a little over 33 years. So I'd like to share with you some of the pitfalls that I've come across over this time frame and hopefully come up with a strategy that will help you to avoid those pitfalls. So let's get started with legacy planning if we can. Now, as most of you know, your estate is comprising of several items such as your assets of bank accounts, investments, real estate, business interests, perhaps you might, life insurance contracts, and other personal property and valuables. So once again, if you have any kind of wherewithal, it's a pretty good idea to have some kind of financial instrument, legal instrument, to make sure that when it comes time for you to pass away, that it goes to the people that you want and that you love, rather than have it go to the state and have them decide who it's going to get, who's going to get that. So you manage wealth throughout your lifetime. And as we know, those are the items that we generally wind up accruing. And then what happens as far as the distribution of those assets upon our death? Most of the time, if we're married, it'll go to our spouse, right? But then after the second death occurs, who does it go to? And is it important for you to maintain control of those assets, not only during your lifetime, but after you've passed away? Now, the benefits of constructing a properly structured estate plan is that you'll avoid conflicts with relatives. You know, there won't be any fighting as to who gets what. Generally, it'll avoid delays of sorts, such as probate, as an example. And you can also avoid some unnecessary expenses, especially here in the state of Washington, because really, most people think that the federal tax exemption is at 11.8 million per person. And that is correct when it comes to the federal. But when it comes to Washington state, that state death tax starts at anything over 2.2 million, which I believe with the rising cost of real estate here just in the last 2-3 years, I bet that some of us are probably right on the edge, if not over. So it's important as we, in essence, put together these documents through an estate attorney, is that we also look at having a power of attorney. And the reason for that is that if we're unable to function to perform financial transactions, then it gives someone that we like or love the right to do it on our behalf. Otherwise, if you don't, you're kind of stuck. And then there's also the durable power of attorney, as well as a medical durable power of attorney, or as more commonly known as a healthcare proxy, because obviously if you wind up in some kind of facility and you're on life support, you know, unless you have that medical directive, you know, no one's going to be able to pull the plug and stop that cash machine of going ka-ching, ka-ching, ka-ching the whole time that you're in there. But that particular document will allow whomever you appoint to be able to, in essence, decide whether or not it's time to pull the plug. There's also the living wills or living trusts that are out there. Some cases, if you have property that's outside of the state of Washington, perhaps in Idaho, Oregon, or even California, it's usually a pretty good idea to consider having a living trust or a living will so that you can consolidate it all under one umbrella. Then, of course, there's the typical testamentary will, which is often referred to as an I love you will, meaning that if I pass away, my spouse gets everything that I have. If she passes away, then I get everything that she has, right? And it does go through probate, though. So if you want to avoid that and minimize the amount of disclosure that generally occurs when things go through probate, it might be a good idea to consider doing some kind of a living trust or a living will. And consequently, that's also going to involve doing some trust records as well. So Once again, state conservation challenges, probate, and taxes, which we all have to face. And then also covering some of those final expenses, such as probate, things that could, in essence, wind up being very time consuming. And the fact that if you do have a testamentary will, then there really is no privacy. It's going to be, in essence, disclosed in the local paper, because at the end of your life, they're going to want to, in essence, put up a notice that you've passed away. And if there's anyone out there that you might have still owed some money to or some kind of interest, they have a 9-month period in which to apply and be able to receive their portion or compensation. If they miss that 9-month window, then hey, that's too bad. That's the way it goes. So in 2020, the federal estate tax, if you got way up there, could be as high as 40% on taxable estates of what, 4, 5, and 10 million or above. And as I mentioned, in the state of Washington, it starts at 2.2 million, and anything above that will be taxed at anywhere from 10 to 20% before it passes on to your children. Now, the state and inheritance taxes are different across all the states, okay? There are 17 states and the District of Columbia that have an estate tax or an inheritance death tax like Washington. And the top rates can range anywhere from 12 to as high as 20%. State exemption amounts range anywhere from $500 on up to about 5.7 million, which is well below the federal exclusion, which I mentioned is at 11.8 million. And you need to keep abreast of that because that could be changing in the not too distant future. So the basic estate tax concepts are making sure that you take advantage of, if you're married, the unlimited marital deduction, the federal estate tax exclusion, which is obviously for any U.S. citizen. In the event that you're married to a foreign national that has never become naturalized, then that could be a little bit of a problem. So it's a good idea to look into what type of exemptions, if any, are there. And then the probability of exclusion between spouses is also very important, along with the annual gift tax exclusion, which allows you to give away to anyone that you want, $15,000 per year, and it doesn't create a tax for you being the one that's the grantor, nor the recipient will pay any kind of a tax as well. And that can be to anybody. It doesn't have to be anyone related to you. It could be your friends, your relatives, could even be your favorite financial consultant. I'd be more than happy to accept some of that. No, just kidding. There's also what's called a step up in basis for certain types of corpuses, property, brokerage accounts, and there's a carryover basis rule as well that needs to be addressed. So the unlimited marital deduction basically creates a tax-free transfer among spouses. So you can pay any kind of state inheritance tax at the first death, or you can take advantage of the unlimited transfer and then wait until the second death, which is generally what some people do. And it may be mixed blessings for couples with substantial net worth, as I mentioned, 4 or 5 million and above. You definitely want to, in essence, do some real serious professional planning. Now, just to give you an idea, this is the federal estate tax exclusion going back to 2007, 2008, which back then it was 2 million, very similar to the state of Washington. And last year was up to 11.5. This year for 2021, it's at 11.8. But in either case, you'll notice the percentage that they would have been taking are pretty much up there, 35 on up to about 45%. So do yourself a favor and do some proper planning and minimize, if not eliminate, that tax. Now, the portability of exclusion between spouses, that enables a married couple to potentially double the applicable exclusion between the two of them. Because like I said, on a federal basis, it's 11.8 million per person. So you need to make sure that you take advantage of that in your legal documents. It's not automatic. Upon the first spouse's death, the executor must transfer the deceased spouse's unused exclusion to the surviving spouse. So it's kind of one of those things that you use it or lose it. If a return is not filed or deadline is missed, surviving spouse loses the right to that portability. Very important not to miss that. The potential pitfalls to portability the predeceased by more than one spouse could be a potential problem. Second, third marriages are very common nowadays. Asset appreciation, take a look at, do you want to perhaps not keep those in your estate and possibly give it to a nonprofit or a charity so that they receive it on a tax-free basis, and your estate will get what? A credit on that. So, and you must file the return even if no tax is owed. So keep that in mind, okay? The annual gift tax exclusion per person, as I said earlier, is $15,000 per person per year, and you don't have to be related, okay? Now, the step up in basis versus the carryover basis rule is something to also take a look at. Appreciated assets, when sold, could be subject to capital gains tax. And for appreciated assets held until death, the basis is typically what? Stepped up, right? Step up in basis up to the fair market value as of the decedent's death, which means, let's say if you bought something for, say, $1 million, and when you die, it's worth $2 million, the people or the beneficiaries of that no longer have that $1 million as their cost basis. They now have $2 million. So it'd be like a tax-free transfer, very similar to what life insurance does. And gifts are also subject to the carryover basis rules as well. So there is no step up to fair market value. Now, distribution of assets at death. It could be intestacy, which means you die without a will and the state gets to appoint a trustee through the courts, and they decide how your assets will be distributed to God only knows who. There's also the I love you will, testamentary will, that in essence denotes how you would want things to be passed on after both you and your spouse are gone. And then there's the trust instrument, which has in some cases, some added tax benefits. It all depends on what type, whether it's revocable or irrevocable. Now, some property may pass automatically to a joint owner or to a designated beneficiary, such as through an IRA, retirement plans, life insurance. They all bypass probate and they pass through a beneficiary designation type format. All other property generally passes according to state intestacy laws. So make sure that you update your wills. If you haven't done in the last 2.5, 3 years, I would highly recommend that you do that, because state of Washington just did some changes on the verbiage to certain, medical directives out there. So if you haven't had yours updated in the last 2.5 to 3 years, what you may have currently today might be null and void. So let's take a look at some of the problems with intestacy. It's a distribution by state law. In other words, you don't have any control over how the states decide to distribute your property to those that are closely related to you, or if they can't find anyone, then there's going to be some fees and taxes that have to be paid to locate those folks. It will go through probate, which means that it's made a public record as to how much your estate was worth and who's going to receive what eventually. Guardianship of minor children is also another important item to, in essence, have in your testamentary will, because if you don't, well, then who's going to take care of the children if they're still minors? It's important to address that. Now, generally, a will is a list of instructions to the probate court as to how you want things distributed, right? And the will considerations are who's going to control the distribution of those assets. In other words, who's your executor or trustee? And it may minimize fees and taxes, but it does definitely ensure that you're going to go through probate. Now, premarital agreement is something a little bit different. Generally these come into play whenever there's been a divorce and or second, third marriages, and it helps to ensure the inheritance for the children. Because in many cases, when folks marry for the second or third time, there's usually his, hers, and then ours, right? So you want to make sure that the distribution through that premarital agreement is done according to what you would want to decide. Whereas on a trust, that helps to control the distribution of the estate. And it also may help in some cases reduce the fees. Some trusts, if they're properly structured, can also completely avoid probate, such as a living trust as an example. So keep that in mind. Now, the parties that are involved in a trust would be the grantor, the person that sets it up, right? And then the trustee is in there as to who, how he or she will distribute those to, say, the beneficiary, okay? Those are the three parties that are involved in a trust. Now, the types of trust are either a testamentary trust, which we just discussed, or a living trust, which could be also revocable. So what are the similarities or differences? Well, on a testamentary trust, that's established through a will. It's effective upon the death of the grantor. It does ensure that it'll go through probate, and it may help to minimize some estate taxes. So don't think that just because you have an estate that's worth $1 million or $2 million, anything under the 2.2 that Washington State focuses on or above, that it's not going to be advantageous to have some type of a legal document. It will. So make sure that you get in touch with an estate attorney. And if you don't happen to have one, I'll be more than happy to refer you to a couple here in the Tri-Cities area. And we also have access to some in Spokane, as well as Seattle and Portland. Now, the living trust, it's set up and funded during your lifetime. It is considered revocable because you do have incidents of ownership. So when it comes to things like the federal estate tax or even the Washington state death tax, a living trust, a living will does not avoid that. So make sure you understand that. It can help to manage some of the fees and taxes, and it does avoid the probate process. So it keeps things confidential. And so the only ones that are going to know what your beneficiaries would be receiving would be the attorney and whoever it is that is the listed trustee of your living trust. And keep in mind, it has to be properly structured, so it pays to have it reviewed about every 2 to 3 years. And it can either be revocable or irrevocable, right? So more on that a little bit later. Now, advanced trust strategies that some people use are these right here. A bypassed AB trust, which primarily means that when one person dies, a portion of that estate goes into the A trust for health, education, and welfare of whoever the beneficiaries might be, and the B trust goes into the surviving spouse. In this way, you're in essence dividing up the valuation of that estate and probably taking advantage of the unlimited marital deduction, which is something, remember, there's only a set time frame to take advantage of that. Otherwise, you lose it, use it or you lose it, right? There's also life insurance trusts. One in particular that I'm very familiar with are irrevocable life insurance trusts. Those bypass probate. They don't get taxed on a federal or even a state basis because technically a irrevocable life insurance trust belongs to a trust, doesn't technically belong to you. So therefore it is not calculated as being part of the total value of your estate. And then there are some charitable trusts that might be beneficial to put in place, especially if you have favorite charities, whether it be your church, your temple, your synagogue, or even for that matter, your favorite alma mater. Could be those, right? Now, should you consider a bypass trust and why? Well, it helps to what? Oh, excuse me. Helps to preserve a couple state tax exclusions. That's one. It shelters the appreciation of assets placed in the trust, okay? And that's important because what? The appreciated assets, right, are going to be separate, so they're not going to be taxed, right? So keep that in mind. Apologize, my finger got a little bit too carried away there, folks. So bear with me as I get back to the proper slide here. So another thing that a bypass trust does, it protects assets from creditors and predators. Another thing to discuss with your estate attorney and your advisor. Benefits the children from a previous marriage as well, and it does definitely avoid probate. Now, irrevocable life insurance trust. Generally, it's to do what? Eliminate the estate taxes. So you're using leverage in which, let's say that the taxes upon your death are going to be $2 million, and let's say you purchase a $2 million insurance contract that is placed into this irrevocable trust, and you're paying, say, 20, 30, 40,000 bucks a year, and you only have to do it for a limited time, like say 10 years. So that means that you paid in what? at 50,000 a year in 10 years, about what? About $500,000. And it's going to pay out what? $2 million to pay those estate taxes. So it's like utilizing what? 30 cents on the dollar instead of dollar per dollar to pay the tax, or dollar plus interest if you have to, your beneficiaries have to go out and borrow the money. So keeps the proceeds out of the estate, and it provides immediate cash indemnity, right? So that's one of the reasons why some people use that. There's also what's called the last survivor life insurance contract. It can also be placed in irrevocable life insurance trust. And what it primarily does is it insures 2 lives instead of just one. And it is designed to pay at the second death, not at the first death. Some cases, that's what some people want to do to keep their costs down and control the policy proceeds. And premiums are often lower than the cost of the 2 or more individual policies. So definitely pays to look and get together with an insurance professional to find out which would be the best route for you. I've always figured that, hey, anytime you can use discounted dollars to pay the taxes, why not? Now, charitable giving strategies, just to give you an idea, there are what are referred to as qualified charitable distributions, charitable remainder trust, and charitable lead trust, okay? So providing for your heirs. It's important to draft the appropriate legal documents for all these different types of trusts. In some cases, 1 or 2 might be sufficient. Other cases, if you have a very high net worth and a very complex type of estate, it could take maybe 3 or 4. In either case, it's a good idea to consult with your fiduciary, your consultant, your CPA, and your estate attorney. And it's important to prepare a letter of instructions so that everyone knows exactly what their responsibilities are upon your demise. And also choose a personal representative, an executor. And you should review your estate plan periodically. As I said, every 2 to 3 years might not be a bad idea, because tax laws definitely will change. And if you don't have it updated, then what you could potentially have could be null and void. So why spend all that money to establish this if you're not going to keep it up to date? And the value and composition of your holdings may also change. More than likely, they're going to appreciate, kind of like what real estate is doing here in the area. It's going through the roof. And your family situation could change, right? Could be some children pass away, divorces, right? Other things that need to be taken into consideration, right? So always a good idea to review. And then putting your knowledge to work, right? Should you do it yourself? Well, once again, depends on how complex your estate is. I would recommend going to see an attorney myself. You can work with us, and like I said, we can give you some referrals to other professionals, or you can just procrastinate and just die intestate without a will and let the state decide where all your money and property will go to. I wouldn't do that, but some people do. Now, because of the fact that we're doing this as a digital virtual webinar, we weren't able to get every one of you an evaluation form. However, if you'd like to call our office at 509-735-9518 and ask us to email you or mail you one so that you can give us some feedback as to these 4 segments, we'd be more than happy to do that. So I want to take time to thank you for taking some time out of your busy schedule. Hopefully you attended all 4 of the segments. And if you missed one, let us know. Be more than happy to see if we can provide you a replay of either the first, second, third, or even this last one. In either case, I want to, in essence, also offer you a complimentary consultation so that if you want to come into the office, have us give you a second opinion without any obligation on your part, be more than happy to do that. So you have our telephone number. Our email address is Thomas Doncaster, THOMAS, DONCASTER. It's all lowercase run together at msn.com. Or if you prefer to visit us on the web, it's tomdoncaster.com. Now, one of the items that I mentioned earlier in the first segment that we were going to discuss is the new Washington State LTC, long-term care tax, that has been signed into law, the state of Washington. They're the first state to implement this. However, there's some other ones talking about doing the same thing. And there's going to be a tax imposed on all W-2 employees starting in January to the tune of 58 cents for every $100 of W-2 compensation. Now, there are some exemptions to this. Self-employed individuals that are receiving their compensation through a 1099 are not obligated to participate in this unless they want to. And then another item are the Indian nations. They're going to be allowed to either opt in or opt out. As far as individuals out there that work for a company that are W-2 employees, they will be given an opt-out period between today and prior to November 1st. And the way that you can opt out is that you need to have your own private insurance for long-term care, or it could even be a hybrid where it's life insurance and long-term care combination. Those just started about 6-7 years ago, and I would definitely encourage you to take a look at those. We've done quite a few of them, and in many cases, people prefer those over the traditional one because at the end of the day, how much money are you going to receive back from a traditional long-term care contract if you never use it? You got it, nothing. Whereas on a hybrid life and LTC, there is a probability that if you die in the next 10, 15, or even 20 years, there'll be something left as the form of life insurance payout to somebody that you love or like. So keep that in mind, okay, folks? Thank you very much once again. And if you have any questions of any kind, whether it's any of this material or the Washington State LTC tax, give us a call. Have a great evening.